Listen here. Okay. If you don't answer the question, I'm going to release the lawyers. 25-00791 FY, State of Michigan versus Timothy Dansby.
Yeah, people.
7446, standing in for the attorney of record, Finalizing, and appearing on behalf of Mr. Timothy Dansby, who speaks to my right. Mr. Dansby, can you please state your full name for the record?
Timothy Dansby.
All right, Mr. Dansby, we're back. Do you mind having Ms. Miller stand in for Mr. Gonick for today's hearing?
That's up to the court. I still reserve my right. I mentioned all of the previous hearings, but part of today's process has been going what it's going to continue doing what it's doing, but I still.
Does that mean you don't mind her standing in?
Want to interpret?
Okay, you know what? I'm not going to play that game. That's a yes or no question. Okay, do you want to adjourn it and see who it is? You have a right to have the counsel of record present if you want to be here instead of Ms. Miller. And this is basically for a probable cause conference and adjourn date on a retail fraud first degree. When we had adjourned it before for your lawyers to get video discovery.
Right here, you can see the judge's patience wearing thin. He asked Dansby multiple times, do you want a lawyer, yes or no? But Dansby just won't commit. This is more than stubbornness. Legally, the defendant has an absolute right to an attorney, but he also has the right to refuse one. The danger, if he goes solo, he's held to the same standards as a trained lawyer in a courtroom packed with rules and procedures. That's why judges push for clarity. What do you think? Is Dansby standing on principle or just sabotaging his own defense?
So do you mind her standing in or no? Okay, so you don't want a lawyer, sir? I'll release him if you don't want one. Nobody's gonna force you to have a lawyer to help you. If you want to do it all yourself, do it. Do you want me to release the lawyers?
You know, thing for him soon right now.
Do you want a lawyer? Yes or no? It's a real easy question, sir. It don't take all day. Listen here. Okay, if you don't answer the question, I'm going to release the lawyers. If that's what, because you've been complaining the whole time about, I didn't ask for no state attorney. I don't want to, I don't know what it, whatever you going to do. No, I'm not doing anything. I didn't appoint the person in the first place. I didn't do it. Okay, so you don't want them? Is that what you're telling me? Do you want them? Yes or no?
All on the same.
Sir, listen, this is not going to be a matter of semantics. Do you want one or not? Because nobody's going to force a lawyer on you. I'll be happy to handle this case with you by yourself, doing whatever you can do to help yourself. If that's what you want.
And there it is. After endless circles, Judge Boyd finally calls Dansby's bluff. Let's release the lawyers. You're not getting another one. This is critical. Once a defendant dismisses court-appointed counsel, they don't get unlimited replacements. Judges can't keep cycling lawyers in and out just because someone refuses to cooperate. The subtext? Dansby wanted to delay, but Boyd is saying enough is enough. This moment flips the entire case dynamic. Dansby is now locked into representing himself unless he changes course.
I still didn't get my discovery, so.
So, do you want a lawyer?
I'm sorry, I'm still on the same thing.
I don't even know what that is. Whatever your claim is, I don't know. Okay, let's release the lawyers. All right.
Reserve the right for-
Now, you're not getting another one. I'm just telling you.
I reserve the right for judiciary and judiciary finding on the legitimacy of the court.
You're not getting another lawyer, okay?
Boy, I said
I don't know whatever. What you can reserve what you want. I don't mind.
finding of the court and the legitimacy of the court as far as the argument.
Sir, whatever you want to do, you can do. But since you don't want a lawyer, I can't by law give you one. So
That was three Germans ago.
guess what? So
Lord, have you given me the things that I need?
okay, sir, nobody can give you anything but a piece of paper. They can give you that. They could give you the police report. They cannot give you the videos because there's no way for you to watch them.
Make sure that the law library at the court, give an order that the law library at the court either have a clerk or somebody to present the information for me to see the video. I don't know, maybe you just don't want to get done.
Sir, I don't even know.
I know.
I don't know anything about your law library wherever. All I know is these video files, they're files. They come on a computer.
So, the law library should get somebody to be giving people at the law library a heads up to make it law.
Well, you know what? That's up to you to figure out how you gonna get them.
I'll let the second circuit figure it out. Second circuit figure it. You know, probably judge, second court, Supreme Court, we let them figure it out. I'm straight. Well, I ain't doing nothing.
Ready for me to take them?
Your Honor, would you like, Mr. Donovan to file any sort of motion or
No,
hold order to have him withdraw?
no, I'm gonna write an order out right now, releasing him.
Here.
And so we will reset this, I guess.
Notice how the case slows down again with discussions of evidence, body cam footage, store video, and discovery rights. This might sound procedural, but it's actually the backbone of any criminal trial. Without full access to evidence, a defendant can claim they weren't given a fair shot. Dansby complains about not seeing his discovery, but here's the issue. Jails can't exactly hand over USB sticks and laptops. It's a logistical nightmare. The judge and attorneys have to figure out how he'll review hours of video while in custody. Let me ask you, if you were in Dansby's position, would you risk going to trial without properly reviewing your evidence?
I don't know why we got him. We could actually bring him back out. And he could decide what he wants to do today.
I do know that, he is wanting to have his preliminary examination. That is.
Okay, well, let's set it for an exam then. How many witnesses, Mrs. Shockley?
Probably just gonna be one.
All right. You want to wait for your order? You can.
Okay, thank you. One witness.
Right.
Yeah. One witness and one defendant that's going to make it way longer than it's supposed to be. So factor that in.
Court's available October 3rd at 10:30.
All right. So October 3rd at 10:30. Is the exam date. And could you ask Mr. Gonick to make sure he gets a discovery, what he has, over to this person?
I believe that paper discovery has already been given to him. I'll see if the court or if the jail will allow us to give any sort of thumb drive or anything like that that encloses the videos.
This record, I would advise the court, the discovery, the AV discovery in this matter is 99% police body worn camera, which has the defendant in it, and there's only one in-store video of the defendant walking past the exit. So, we
Okay.
didn't know it.
Okay. Well, good. Just make sure he sees it. Just some of your best efforts on that.
So where does that leave us? The exam is officially set for October 3rd with just one witness expected. On paper, it sounds straightforward, but with Dansby representing himself, expect delays, objections, and confusion. Judges hate when defendants reject their lawyers because it almost always turns a simple case into a marathon. Today's hearing highlights the tug of war between the defendant's rights and the court's duty to keep things moving. Now, we want to hear from you. Do you think Judge Boyd handled this fairly, or was Dansby being deliberately difficult? Drop your thoughts below. And if you found this breakdown as wild as we did, make sure to hit that like button, share this video, and subscribe for more jaw-dropping courtroom moments. You won't want to miss what happens next.